Good morning, everybody, and welcome to the East Brandywine Township Board of Supervisors meeting for today, Thursday, March 7th, 2024. Just a reminder, recording device will be used during this meeting, and we're going to open the meeting with the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, we're going to open the meeting up with a public comment for agenda items, rules of conduct for public meetings established in Resolution 2001-08. The time allotted to each individual making a comment shall be 3 minutes, unless otherwise set by the presiding officer. Additional public comment may be granted at the discretion of the presiding officer at the conclusion of the meeting. So we'll open it up for public comment for agenda items.
Mr. Chair, I would recommend that for agenda item 5D, that we solicit public comment prior to a board vote.
Okay. Okay.
How about the other items? Are you going to have public?
Yeah.
Mr. Hoffman didn't hear.
Yeah, so I was opening up for public comments for agenda items. We are going to put, obviously, 5D, since I know there's some questions regarding 5D. We'll open it up for public comment on that as well. So if there's nothing other than 5D, then we'll go ahead and move on.
Can I comment?
Sure.
I have a comment.
Yep, understood.
Stand off.
At 5D, yep.
Yeah.
No, not yet. Just
Okay.
Sorry. So when we get to 5D, I'll call you up. Okay. So there is no public comment for agenda items other than 5D. We have one comment for that. We're going to move on to minutes of previous meetings. And do I have an approval for the February?
I'll make a motion that we approve the minutes of the February 15th Board of Supervisors meeting.
I'll second.
All in favor?
Aye.
Okay, I'll turn it over to, well, we have the treasurer's report and the authorization to pay bills.
I'll make a motion. I've reviewed the bills, and I'll make a motion to accept the treasurer's report and authorize to pay the bills and approve the payroll.
I'll second. All in favor?
Aye.
Aye. Okay, old business, financial security release for Mapleview. I think we'll just, do you want to do them all at once for Mapleview, Tom, or do you want to go in order?
I think you can do all three of the Mapleview together.
Okay, so I'll read it. Financial security release for Mapleview Phase 1. That would be release number 4. And financial security release Mapleview Phase 2. That would be release number 3. And financial security release Mapleview Phase 3. Release number 2. I'll turn it over to Nate and Tom for that.
I can comment on it. These are items that are authorized by the Pennsylvania Municipalities Planning Code and also the Township Subdivision and Land Development Ordinance. This applies to all 4 of these, including the one for Applecross. As the board knows, developers post financial security with the Township to ensure that the developer completes the common improvements in the project in accordance with the township ordinances. As the work on the developments proceeds, the developers can request that a portion of the financial security be released because the items that are covered are completed. The code requires that the township engineer certify to the township that the improvements have been completed in accordance with the approved plan. In the case of all 4 of these, but we're addressing A, B, and C now, we do have correspondence from the township engineer wherein Mr. Klein states, we have observed construction of these improvements and certify they have been completed in accordance with the approved plan. So that's a statement in accordance with what I just explained. And then the code says, and I'm going to read it verbatim, upon such certification, the governing body shall authorize release by the binding company or lending institution of an amount as estimated by the municipal engineer fairly representing the value of the improvements completed, or if the governing body fails to act, the governing body shall be deemed to have approved the release of funds as requested. So I can answer any questions the board might have about that, but as I said, in the case of A, B, and C, we have the certification from the township engineer.
So the only comments that I have is that we should read into the record the amounts for 1, 2, and 3.
The amount for Maple View Phase 1 is $247,348.12. For Maple View Phase 2, it's $271,611.48. And for Maple View Phase 3, the amount is $240,068.26. And in all three cases, there are balances still remaining as financial security to complete additional improvements.
I have no questions. Anybody else?
Any questions you want to make?
No, I don't have any.
I'll make a motion that we approve the financial securities release for 1, 2, and 3 for Maple View.
Phase 1, 2, 3, release number 2, 3, 4. Okay, and I'll second. All in favor?
Aye.
Aye.
Okay, the next issue, I'm going to actually turn this over to the vice chair. As I have stated before, I have a I have a conflict of interest with both parties in the next item. So the financial release, Applecross Phase 5B, release number 4. I'll turn that over to Carl.
So, Mr. Chairman, you're going to recuse yourself from consideration of this matter, and you should file a memorandum with the Township Secretary explaining why you're recusing yourself.
Understood.
A written memorandum. Thank you.
And for the record, I do work for the HOA, and I also had a Pulte house, so I don't see any further, but I'll certainly address that.
All right, thank you, Chairman Scribner. Is there public comment on item 4D?
Sorry, 5D, Mr. Vice Chairman. Sorry.
5D? You're on. If you could come up to the podium. And the reason we want you at the podium really is so we record the meeting so we can get proper minutes.
Okay, thank you very much. And thanks to the supervisors and the rest of the representatives of the township for allowing us to speak. My name is Bob Hoffman. I'm a resident in Applecross. I am the vice president of the Homeowners Association. The supervisors were very kind last month to defer Pulte's request for the escrow release to this month, and we greatly appreciate that. We are currently in negotiations with Pulte to close out our objections with them on the release of the, not the release, but the items that in our perception are incomplete in 5B. We've already agreed upon just approximately half of the items that we believe are outstanding through a negotiation, face-to-face negotiation with a Pulte rep. We have a few more items to go that are not released yet. We gave Pulte till 5 o'clock this evening to either accept, reject, or comment on our proposed settlement. We have not heard that. Be that as it is, the township manager handed me this letter and report from Pannoni Associates, and it's the first I've seen of it. But glancing through it, there are several items that are represented by Pannoni as being complete in 5B that are not complete, or at least not agreed to with Pulte. Just a few examples. There is a retaining wall on the entrance to 5B off of, I believe that's Zinn Road. over there.
Bollinger.
Well, no,
5B?
yeah,
So it would be Bollinger and, I'm sorry, Bondsville and,
not
yeah.
Zen,
No, it's.
Bondsville.
Yeah.
That wall, if you've ever driven in there, there's a pretty large bulge in it. There's been some movement in that wall. And we don't know if it's going to fall down when somebody is driving across that entrance. We're not sure. We've had our engineers look at it. We have a proposal in the Pulte. That's one of the items that we're currently negotiating with them, but it's not closed down. Landscaping is another issue that is not complete.
Is that a wing wall on the bridge? On the bridge that goes across the street?
Yes, it's a block wall.
Okay, but that's associated with the bridge. I'm
Yes.
just trying to get a feel for
Yes,
where
if
we're
you
at.
come in off of Bondsville.
Bondsville, yeah,
It's on your left side as you enter.
okay.
So it's Locks Farms in Bondsville. That's what I was
Yeah.
looking for. Locks Farm.
And if you look over the railing, you can see it. It's very plain. Measurements have been taken. The wall is definitely bulging out. So we'd like to get things like that resolved. The landscaping is not resolved. We have a soil testing, which is a part of the documents that incidentally were produced by Pulte, by their consultant, require soil testing in 5B. They have not produced their findings on the soil testing. We suspect, not saying it's a fact, we suspect that they never did the soil testing. I can keep going. Landscaping trees. There's a row of trees between our homeowner's property, common area, and Scott Risman's property, which our tree expert has told us some of them are about to fall down, and which direction they fall down, into Risman's property, into the common area, or possibly hitting a homeowner's house, which could be very dangerous. That's not resolved. So I'm new to all this. I ask that you bear with me, but if there's a way that you can defer, not saying deny the request, but defer decision on the request until we've had a chance to clear up our differences with Pulte, we'd appreciate that greatly. I just talked to our attorney. I'm sure you're familiar with Adam Marcus. And Adam told me that Pulte's attorney, Bill Ryan, is having surgery, hasn't had a chance to respond or even review our proposal. I think that's coming within the next several days, but if there's a way this decision can be deferred, we'd appreciate it. And that's it. Do you have any questions?
Probably we have quite a few questions.
Well, the question to defer, I think, has to go to Tom with regards to our obligations.
Well, before it goes to Tom, I'd like to ask some questions on that. I understand your request to defer. You're asking us as supervisors to defer something that doesn't really involve us. It's you and Pulte. So, although we're kind of on the horns of a dilemma here in that our solicitor, reading right from the law, has stated that if township engineer certifies that it meets the plans that were approved, since we're holding the money in escrow or in trust for Pulte, we have to release it. We have no ability to hold up those funds, even if we want to, if our engineer says the work is done. Is that basically correct?
It is correct, and if I may, I just want to point out one other thing. The financial security is based on a tabulation of a series of improvements in financial amounts that are securing the completion of those improvements. And you see that attached to Pannoni's release letter. So what is requested to be released today relates to specific items. And I don't know whether any of those items relate to what Mr. Hoffman stated, but for example, you see item 2U, and that's a release of $1,426.80 for permanent stabilization, seed, straw, and mulch. So the township, and then if you look down that column, you'll see what is being released or what is being requested to be released in this request. So the township doesn't take financial security for every possible improvement in the development. For example, in this development, I know that there's a sign or wall at the entrance that identifies it as, if memory serves, the towns or something like that. And I don't know that there was any financial escrow for that because that's not considered a common improvement for which the municipality's planning code authorizes financial security. So what Mr. Klein is saying in this certification is that these specific items which he is certifying as complete are the items that, to be repetitious, are certified as being complete. So whether any of those relate to Mr. Hoffman's complaints, I don't know, but I would also agree that these are two separate issues. If there's a private dispute between the homeowners association and Pulte about, say, the quality of the work, that issue is separate from what the township's relationship is to the developer to guarantee that the common improvements that are listed in this tabulation are completed in accordance with the plan. So we do have an obligation under the municipality's planning code to release the funds. However, whether or not the township does that today or later is up to the Board of Supervisors. If we don't do it today, we risk that it's a deemed approval and Pulte can take action to enforce that deemed approval. Sorry to be so long-winded.
Mr. Vice Chairman, may I ask?
Yes.
I appreciate Mr. Estes' comment on the deemed approval. In your when you were reading from the MPC, was there a timeline described?
And you're very observant because I skipped that. It says if the governing body fails to act within said 45-day period. Now that refers to the obligation of the governing body has 45 days from receipt of the request for the release to take action, and I'm paraphrasing. 45 days applies to the township's engineer's duty to certify completion. Once the firm does that, then the obligation shifts to the Board of Supervisors.
You have me confused there. So it's 45 days from the date we received the letter?
Right, 45 days from receipt of such request within which to allow the municipal engineer to certify in writing to the governing body that such portion of the work upon the improvements has been completed in accordance with the approved plan.
So it's not the date of the letter, it's the date they asked for the release.
So I guess that's the question. When did they request that release?
Right.
5 days from the receipt by the township of the request.
All of
So it's not the date of the letter? February 7th?
No, not the
receipt.
date in Pannoni's list.
The request at the stamp time it came into the township.
Right, so do we know that date?
I posed the question for the second part of my statement, which is that I would not recommend that we table this matter without consent of the developer due to the risk of a deemed approval. I highly suggest we adopt or seek a continuance.
Do you have to ask the developer for that continuance?
We do. And we did get and that's another thing we should mention, is that this was on your last agenda, I believe 2 weeks ago. And we requested that the developer give us an extension until today, which the developer did. So that, they did give us the extension. That extension expires today.
I'm sorry, I don't mean to belabor the point. Effectively, doing nothing and voting yes are the same thing today.
Yes. So,
You had other comments?
no, I just wanted Tom's opinion on the matter so that we could get some clarity on how we're going to proceed. And it seems to me as though taking no action is essentially taking action. Unless we get the developer to agree that they're going to give another extension to the township to deal with this request.
Go ahead, Mr. Hoffman.
Thank you. Just a couple of comments. When I hear that it says that 45 days to take action, it doesn't, to me, it doesn't mean approval. It means some sort of action.
Well, if we don't take action, it's an
Well, the
automatic
request.
approval.
It would be
I'm
the
sorry?
request.
If we do not take action, it's an automatic approval. Us taking no action is deemed an approval.
Okay. Can you?
I just want to, if I don't mean to interrupt, but just to
Please.
clarify once again, upon such certification, the governing body shall authorize release. It doesn't say.
That's approval to
Right.
me. Okay. Pulte's representative could have been in attendance at this meeting also, unless.
I think they do have a representative here.
You are? Yes, Bill Krieger. Oh, you're Bill. I didn't recognize you with the hair. Thank you. Nice to see you. Seriously, looks good. There are items on here that are, in my view, clearly involved with our dispute with Pulte. When I say dispute, we're negotiating it now, and we're very close. The retaining walls listed on this itemized list. Landscaping is on this itemized list, or light poles are on this itemized list. So there are items on here that Pannoni is certifying are complete, and they're clearly not. And take a ride into the entrance of 5B at the bridge, look over the side, left side as you come in, and you'll see the big bulge in the wall. So we're requesting, and we don't know, I'm not a lawyer, just a humble citizen, what the implication is. If there's items in here that are to us, to Applecross, to the board, demonstratively not accurate, and the township votes to accept this, where does that leave us? And where does that leave the township? Or Pannoni, who is representing this, is complete.
Would you come up to the microphone?
Yeah, I
Bill,
think it's
please?
time for Bill to weigh in
Time
here.
for me to move?
Yep. But don't go far.
Look shorter if I stand next to you. So, good morning, Bill Krieger with Pulte Homes. I'm not going to get into all the details of what's going on in the litigation between the association and Pulte, which is a rather common occurrence when we transition from developer control to homeowners association. It's a negotiation to fine-tune some of the details and the quality of it. So I'm not going to get into all the details of what we're discussing. But specific to the retaining wall, what had happened was, I guess a couple years ago, there was a really, really bad storm event, and the whole area flooded. It caused some settlement at the base of the retaining wall, washed out some of the soil that was allowing positive drainage away from the retaining wall, and then over subsequent months and years, that part of the retaining wall actually settled. This was observed by Ingram Engineering, which is a third-party geotechnical and structural firm, not affiliated with Pulte. It's a third party, and they observed it. They did some soil testing, and then subsequent to that, we went out and corrected that issue with grading, and they certified that there's no further structural issues with that retaining wall. They generated a letter. That letter was provided to both the association's counsel as well as the township engineer to say the wall is not bulging. It's actually had settled, but it's not structurally compromised any further. The landscaping portion of it, we're not a maintenance company. We install it. We get people to say it was installed just like any tree you would buy at Home Depot. Plants die. That's part of the negotiation. Ironically, I tried to get Scott Risman, who's a homeowner at Applecross, to take care of this stuff and pull it out of the litigation, but he was unsuccessful at working with the board at not suing himself. So that's part of the ongoing negotiations. So if there's any questions I can answer for you for the board, but we got the NPDS closed out. We satisfied all the requirements. We had it inspected year over year over year, and I'm respectfully requesting that this be approved and released.
So you're, go ahead, I'm sorry.
We will continue to negotiate with the association like we've been doing since the first initial phase through this phase. We're not going anywhere. We're going to continue to negotiate. We want to be good neighbors with our property owners, but it's just unfortunately it's a long process with a lot of attorneys involved that make a lot of money off the project, but we will continue to negotiate.
Not me.
Not you, of course. I'll pay your bill anytime.
The quick question is, so at this point, you're not inclined to extend this request?
That's
beyond
correct.
today's meeting?
I'm not authorizing an
Okay.
extension. All right. Okay, thank you.
Thank you.
Can I respond?
Sure.
We have not had any discussion with Scott Risman or our counsel per the last time I spoke to him, which was just a few days ago. Matter of fact, he said specifically he hasn't discussed anything with Scott Risman. So I don't know where Bill or his people got that information. So there's no agreement with that. In terms of the wall, plain view, you can see the walls bulging. We have a proposal into Pulte on how to handle that. They have not responded, which, okay, I won't go there. They have not responded to it, but I asked that you take a ride, or Chief, ask one of your officers to take a ride and look over the side and just say, do you see anything odd there? And I'm sure they're going to say there's a big bulge in the wall. Soil testing is not maintenance. It's not maintenance. You have to certify the builder, in this case, if the soil has been done correctly. We don't know if it has or has not, but we've asked for repeatedly the results of Pulte soil testing. Bill Ryan, who's the attorney with Pulte that I know, and Bill I think is a good guy. He was unaware of that requirement, but we still haven't heard anything about the soil testing. What happens if they have it done, they come back in and say, you're short 3 or 4 inches of soil, topsoil, on that site. So, as a homeowner, representing the homeowners, it's hard for us to concur, and I know we have no control over it. That rests with the supervisors. Negotiations are ongoing. We've settled a lot of the items open, and I'm sure Bill is aware of that. We're very close, but we're asking that, and I don't know all the legalese behind it, to defer, to take it under advisement, something of that nature. I suspect, knowing good lawyers, and I think Pulte's, I guess she's in-house counsel, Bill. A good lawyer does not want litigation because they're going to spend a lot more than it was worth to defer this, take it under advisement, somehow not close it out. To give these negotiations a chance to work out would be very appreciative from the homeowner's part.
Right, but the problem is it's not our place to
Mediate.
To mediate, yeah, I was going to say to.
We're not asking you to mediate.
Yes, you are, because unfortunately, listen, I'm not in necessarily if I were in your shoes, I'd be saying what you're saying, but and I understand it, but the problem is the negotiations are between the homeowners association and the developer. Our responsibilities has nothing to do with what your negotiations are involved in. What we're having to do is certify a release of monies we hold in escrow. They're not our monies. It's monies put up through cash or letters of credit or what have you to guarantee that they do the work. And our engineering, when you say come out and look at it, our engineer, that's what we pay them to do, they go out and look at it. We can look at it, but we're not engineers. So if our engineer, by statute, writes that the work is done and complete according to the approved plans, we don't have a choice. That's why they put the date, a date that in action automatically approves the release, because they don't, the people who drafted the municipal law don't want us to do what you're asking us to do, to keep kicking the can down the road. If Mr. Kreger would say, sure, I'll give you a 2-week extension, that's fine, but he has just said he will not, and he has a right to say no.
If I may ask Bill a question in a minute, can I address a question to Thomas?
Yes, it's.
Sorry to call you Tom.
No, Tom's fine.
If there's items in this list that we know are not accurate, such as the landscaping, soil testing, that's landscaping.
Well,
You know, we don't know that it's been done.
Tom, can I step in maybe?
you may.
Yeah, because we're beating you up now.
Please do, because I was.
So my name's Nate, I'm with
Lean towards
Benoni.
you next.
That's my letter. That was my recommendation. I don't take that recommendation lightly. I work on these projects. I've been doing this for 25 years. I've worked with Mr. Krieger on multiple projects. I've worked on multiple projects here in this municipality. The indications that things are incomplete is inaccurate. I'd like to clarify a few things right now. First of all, the retaining wall, visually, I agree. It catches an eye of a non-professional as being something that doesn't look right. However, that has been investigated by a third-party engineer who essentially designed retaining walls, and he's certified that that wall has been repaired and is good shape.
Which is Pulte's engineer.
That we have reviewed and accepted. That has been provided on multiple occasions to your attorney for the HOA, Adam
Okay.
Marcus. Second, regarding the landscaping, last fall, before all the leaves died and the trees don't look great, we completed inspections of all of the landscaping, and at that time, all the landscaping was installed correctly and in place. Okay, so that's been done. That was done by a landscape architect, registered landscape architect with our company. That was done last year. We have been engaged with the Pulte team and their contractors from the beginning of this project. We did not come in just last year. We've been engaged.
Have you been engaged with us?
What's that?
Have you been engaged with us?
I have reviewed the detailed engineering report that was provided by Adam to our office last summer. We've provided that to the Pulte team. We have reviewed those items in detail on site. We have replaced countless pieces of curb, sidewalk, trees, basin restorations, amended the basins, and we've worked with the Pulte team on all of those items to get those resolved.
They're not resolved.
They are absolutely resolved.
I'm telling you they're not.
Well, then we can disagree, and that's why you were negotiating.
And our engineer
Your engineer
is, let me finish,
not here. Go ahead.
who's not here,
It
but
was
his,
not updated their report.
but
from
his
2 years
report
ago.
is here.
What date's the report?
This is June 23.
23. So it's not a current report.
We've asked Pulte to certify
Certify what?
soil testing as an example. Show us,
I have no idea what you're talking about regarding soil
Dave,
testing.
excuse me. Soil testing is a requirement of documents. We asked them,
Again, I'm sorry to interrupt you, but again, on the township side, we are not party to an HOA or an agreement between two parties, the HOA and Pulte. So we have no party to a soils test. We don't even know what the requirement you're referring to is.
it's in the documents. And you say you looked at the
Document refer to
the site documents.
site document?
Yeah,
What's that?
approved by the township.
Site
And
document.
we asked Pulte to simply request it. Show us your soil test results. Crickets.
In 25 years,
Bill,
I've never received
Do you
a
know
soils test
that
document
the
on
soil
any
testing
project.
was done?
I can interject. I was asked that question to provide the soil testing. I don't know what soil testing you're talking about. If it's the soil testing when we did the infiltration testing, at the design of it, which is referenced in the documents, that was done before we built the site. So that's why I went back to Bill Ryan and said, can you be more specific as to what and where and when the soil testing was required? Because the soil testing that I see on plan was all the post-construction stormwater management for the design of the site.
This is soil testing.
As a point of order, Mr. Vice Chairman, I'm sorry. We're having an excellent and productive dialogue, but we're making a terrible video and record. I would recommend that all speakers use a microphone and that all comments be addressed to the chair. Thank you.
Thank you.
Thank you. That's Carl, the chair, that soil testing, the testing is required to be done post-construction, submitted to Penn State for their review and their comment on it. All we've done is asked for the results of that review. And we get crickets from Pulte. No offense to Bill or anyone in this room. Are you working with him?
I'm looking at Bill because I've never
Well,
heard that
I see you going back and forth with Bill.
Bill, if he's aware of this requirement, because it might.
I'd like to know, are you working with him?
Excuse me. In 25 years, I've never required a Penn State study of soils on any.
What if it's in the documents?
I'd love to
You
see
may
it.
have been wrong.
I may be wrong, and if I'm wrong, I'll admit it. I would love to see what we're talking about, but on a project of a several $million-dollar project, I am clueless on what the specific ask is on this specific.
For the record, Carl, I am disturbed that the township engineer is communicating during this meeting as if to get his concurrence or comments.
Excuse me. If you got,
You're the one that's come across hard, not me.
because I've been working on, I've met you for the first time today, and I've been working on this.
Well, I know your name.
All right, gentlemen. I want to keep it productive. We don't have to argue back and forth.
What happens if we prove, if the escrow is released, and his letter that he said he wrote and studies that he made are proven to be incorrect? What happens then to the township? And I guess that's what I wanted to address to you, Thomas.
That's what
You want me to respond?
yes, would you respond to that?
Again, Pannoni is the township's hired township engineer. Pannoni's obligation is to the township. It's not to the homeowners association.
I agree.
It's not to the developer Pulte. However, the township engineer, just like I do as a township solicitor, on occasion communicates with the developer because we have to determine facts and perhaps get answers to questions. So the certification that Pannoni has made this morning is to the township. The township is the recipient of it, and I guess we could say is the beneficiary of it. The homeowner association, Pannoni is making no certification to the homeowners association.
Say that again. I'm sorry, say that again.
Pannoni is making no certification to the homeowners association. They're
Making it to the
making the
township.
certification to the township
Understand.
for the limited purpose of the financial security release.
Understand.
They're not making a certification about the quality of the construction, whether there might be a crack in the sidewalk. They're making a certification that we've said this several times, that the improvements that are requested release are completed in accordance with the plan. If there's an incorrect statement in there, the liability, if there's any from Pulte, runs to the township, not the HOA.
Can I say one more thing, Bob?
And I'm not suggesting there is any incorrect statement or liability.
I know you're not. But if there is, call it incorrect statement. It's the township that's relying on this document.
We're not relying on the
No.
document you're holding. That document has nothing to do with us.
The Pannoni letter?
You held up the document from your engineer, just for the record. Oh, okay.
That we are
We
relying
are
on.
relying
That's what I'm
on-
discussing.
We are relying on and I think you said Pulte, we're relying on the February 7th, 2024 letter from Pannoni, revised March 6, 2024.
And I just received this morning.
Certifying a release of $178,134.91.
Thank you, Thomas. There are items in Pannoni's letter. I just received this morning, and granted, it's a very high-level review. It appears to us that there's at least a couple of items on this list that Township is relying on, that Nathan is strongly, strongly commented that it's accurate, we don't make mistakes. What happens if he did? And the Township is...
Well, then you have every right to enter an action against the engineer.
If you think you have a cause of action.
We have no
As I
direct link.
said,
So we would...
He has no legal obligation to the HOA. Pannoni has no legal obligation to the HOA.
So we would have that discussion with the
Let me
Township.
finish. Based on what I'm hearing this morning,
Okay.
that doesn't stop anybody from suing anybody. But I need to say again, because we're going on and on, frankly, about something that we have no control over. The Board of Supervisors' choice this morning is either to take action to approve the release or do nothing. If they do nothing, the release is approved. So those are the options. There are no other options. If the supervisors took action, we deny the request, it's a nullity because it's deemed approved by statute.
So what the Township is saying, that tax-paying homeowners are being ignored.
No.
But
No.
Let me finish. We have no right
No,
to...
you're going down a new rabbit hole that doesn't have any rabbits in it.
It sounds like we have no place in this.
Well,
You do.
I think that
It's with the
board-
developer, I believe.
The board just gave you, I think, 20 minutes to state your position.
Very kindly.
So you do have a say. The problem is, the board doesn't have the legal right to do, I'm not sure what you even want them to do. What I see is you want to use the Township as leverage for your negotiations with Pulte.
We are
And
simply...
we don't have the authority to be used as leverage.
We're simply saying, in our engineer's opinion, that there are inaccuracies in this report that you're relying on to release the escrow.
So your engineer's report from June of 2023?
Sorry?
Your engineer's report was dated June of 23?
Yes?
Just
Well,
clarify
it's
that.
easy for them to pull up the records and show us if they made corrections. We've asked for their records and it's crickets.
Mr. Chairman. I would let, yes, Mr. Kreger has asked to speak. It's time to let him speak. I'm sorry, did you have another point?
I'll make this quick and one final comment. And we take natural products, man-made products, and we put them together and we do it out in the environment. We're not without error. We always make mistakes, all right? Our position is we will continue. We haven't been in business for 70-plus years delivering thousands of homes a year without doing the right thing. And my position is, and Pulte's position is, we will continue to do that right thing and work with the association to identify any issues that are wrong, and we will correct those issues. That's all I'm saying. This releasing of the bond, the releasing of the security is a completely separate matter than what we're dealing with the association. So I would respectfully request that you release the financial guarantee so I can check that box and move on and continue to negotiate with the association. Thank you.
You want to make the motion?
One last comment, then I'll get out of here.
I think you should make the motion.
This is my second Pulte home that I bought. First time I met Bill was, here at Applecross, but I bought the second home. We've had Pulte in mediation. Can't discuss the details of that mediation. It was like pulling teeth to get settled. We feel we're being hung out to dry. We know, in our opinion, there are items on this list that are not right, no matter what Nate says. And I also, just for the record, I'm going to close with this, I object with Nate and Bill giving signals to each other while I'm up here speaking. That's wrong. And that tells me, I wonder if they're in cahoots. I'm not saying they are, I'm not saying you are, but that was clearly going on. So I'm asking if you could, I don't have all, Thomas, I don't have all the legal background. I'm just a humble retired homeowner. But, geez, we'd sure like to have some kind of deferral on this.
All right, thank you.
Okay, thank you very much. Sorry to go on so long.
What?
And we love living in Applecross. If I didn't say that earlier, we love East Brandywine. It's a great community. Thank you.
I'd like to say something
Go ahead.
first. I'm happy to hear all the conversation. I still say, unfortunately, Mr. Hoffman, that we're in a position that we must follow the law. We must follow the second-class code and the municipal planning code, so I don't know how we can interject ourselves into a situation between the homeowners and the builders. It's not our responsibility. You're doing what you should do in the homeowners. We have to do what we have to do as supervisors, and I know, even though we have sympathies for the homeowners association, we even have a recusal because, you know, but we still can't just ignore our responsibilities, which means we also can't ignore our engineer. If we don't follow the statutes and have a professional engineer review everything and then writes an okay letter, well, then we're not doing our job. So I don't see how we can get involved. Is there a motion to?
Yeah, at this time, I think we've had a pretty healthy debate over this issue. It's clear that the township has to approve it or recuse it. Either way, it's going to get approved. So at this time, I'm going to make a motion that we approve the financial security release for Applecross Phase 5B, release number 4.
I'll second it.
Again, in the amount of $178,134.91.
And I second it.
All in favor?
Aye.
Aye.
Thank you for your
Well, thank you.
concern and presentation.
I realize
And we right, and I hope
We're
you
not
understand.
homeowners,
But I hope you understand it's a technicality that we have to follow.
Someone is going to be here for a very, very long time. Pulte is gone.
Well, off the record, Polly has been in this township for, I
15
think,
years.
close to a decade, or maybe longer.
15 years.
15 years. And
20
in my experience
years.
with Polly and Mr. Krieger, they have always done what they said they were going
I have
to
no
do.
problems with Pulte.
They have always done what they said they were going to do.
I have the, shouldn't say privilege, experience to go through a mediation, very serious mediation with Pulte, which is settled. Okay? They are not the kind lambs they're painted to be. They are not.
I didn't say that.
I'm sorry, to give me the point of order. As a practical matter, I don't have a means of cutting this out of the record.
Sorry
So
about that.
there really is no off the record, so to speak.
I'll get you a
We're
pair of
recording
scissors.
for later broadcast on YouTube.
All right. I turn the meeting back over to our real chairman.
Okay, subdivision and zoning applications.
They got Chester County
Yeah.
250th first.
on new business.
Oh, I'm sorry, yeah, is Jim not coming or somebody doing it for him?
He's in Hawaii.
Are you gonna do it?
Yeah, so
Don't we have a Zoom meeting?
yeah, the speaker on this agenda item, Mr. Chairman, is
2
on
a.m. there.
vacation, several time zones away. I know nothing further than what is included in your packet, so at this time I'd respectfully ask that we table this agenda item till a date when Mr. Buxala can address the board.
I was thinking. Okay, so we'll go ahead on to zoning and subdivision, there are none tonight, but we have the ordinance and resolution for considering ordinance number 1 of 2024, an ordinance of the Township of East Brandywine, Chester County, Pennsylvania, authorized by Pennsylvania Municipalities Planning Code, amending the East Brandywine Township Code Part 3, known as the Land Use Code of the Township of East Brandywine, Chapter 300, Section 300-17. Definitions of the Chapter 399, Section 399.78, landscaping and site design, and Section 399-79, buffering and screening of visual impacts.
Mr. Chairman, this is an ordinance that was reviewed by your Planning Commission and recommended for approval. It was reviewed by the Chester County Planning Commission, and they recommended it be approved. It's been properly advertised and is ready for adoption or enactment by the board.
Any questions on this?
I have one comment, Mr. Chairman, and that is that the draft legislation refers to a plant list to be adopted by resolution. That plant list is not part of the draft ordinance in front of you. A resolution adopting a plant list is anticipated to be on your next meeting's agenda.
Understood. So do I have a motion for ordinance 1 of 2024?
I move that we adopt ordinance 1 of 2024.
I'll second.
All in favor?
Aye.
All right, amendment to draft ordinance amending the maximum units allowed in the R1, R2 district development as residential clusters as previously approved by the advertisement on February 15th.
All right, so my name's next to that, and what I wanted to discuss. At the last meeting, we had a pretty healthy debate over this ordinance, and since we're all on board that we're going to adopt it, I took a look at it, and in reality, I realized that we may have missed a minor, or, well, I don't think minor, a detail that we should certainly consider. And that was both R1 and R2 have a requirement of 30,000 square foot minimum lot. The change puts the multiplier for R1 to 0.37 and the multiplier for R2 to 0.47. So that's about a 15% reduction in the number of units that can be built on those areas. And with that, I noticed that R1 has a 50% open space requirement, but R2 had a 40% open space requirement. So with the additional area of the 15%, I thought, well, if we're going to do this, let's do this and add 50% for both zoning districts as a required open space. And we looked at the design, potential designs with regards to streets and stormwater and the number of lots that would go on to a particular property, as say hypothetically 20 acres, and it would not cause a problem having a 50% open space requirement. Nate, you're down here, and if you have any comments with regards to that.
Your suggestion is switching from 40 to 50.
To 50 in R2.
Yeah, I mean, again, I think that's
And that,
almost negligible in regard to the larger project in the scope of it.
Does it make R2 almost then very similar to R1? I mean, is there
you can put a couple more units in the R2.
Okay, so you still
the multiplier. Yeah, I think depending on the size of the lot, you know, the minimum
the reason I raised that question and I know you spent a lot of time looking at it, was that the minimum lot sizes are the same in both.
Minimum lot sizes are the same, and depending on it's 10-acre minimum for a project, so you're talking about one unit between the two. So this way, you know, from the open space perspective, you're guaranteed half the property will be in open space for both R1 and R2. But I think that's the you know, that's what it seems everyone's looking for now. So that's I didn't want to bring it up at the last meeting.
We need a motion to amend this?
I don't think, if there's a consensus of the board that, and I think what we're talking about is amending section 399-31B2 to change 40% to 50% If there's a consensus of the board that we do that, I will work on the ordinance with Luke. We'll get it advertised. We may have to resubmit it to the Chester County Planning Commission and get it ready for enactment.
Correct. The last action taken by this board was to authorize staff to advertise this draft ordinance for adoption. If we make this amendment, there would be, it would return to the county for Act 247 review. So,
In addition, we had deferred the, and I may not be using the correct term, adoption or implementation of this ordinance for 1 year. So with that, we had plenty of time to make sure that what we're doing is being covered, so.
What I would suggest we do is where it says effective date, it would say the ordinance shall be effective 365 days from the date of enactment set forth here and below. In other words, if you enact it on, say, your April PM meeting, the ordinance would be in effect, but it wouldn't, I'm sorry, the ordinance would have been enacted, but it won't go into effect until April of 2025. In other words, it won't apply to anybody or any landowner or development until April of 2025.
And this may bring up another debate, but if you guys are interested in leaving it at that or making any adjustments to that, then, you know, at this time would be the time to have that conversation.
I'm fine with 1 year from when we implement it, because
Okay.
we agreed the last meeting that we would give it a year, but we don't know when that year's going to start.
Okay, that's fine. I just want to make sure there hasn't been a change in
I think we
thoughts.
should stick with the spirit.
Okay.
Okay, thank you.
We just have to tell the county they really only have a couple days to review it, since they've already reviewed it. It's one number.
That 45 number will appear again. 45 seems to have been a magic number to the writers of the MPC.
No, there doesn't need to be a motion.
All right, so I'm going to move on to
Adjournment.
public comment for non-agenda items. Seeing none, notices an executive session was held Wednesday, February 27th for personnel matters. Do I have a motion to adjourn?
I move we adjourn.
I second. All in favor?
Aye.
Aye. Thank you, everybody.